Do I need to repeat my Metropolitan Short-Term Rental Appeal Board hearing for the 28th of February? We have one case on today. That would be Tony Arsenault, if I'm saying that correctly. Sorry? Tony, okay, Toby. And I have my glasses on and everything. That's what I was worried about. Okay, very good. Well, I'm going to turn it over to Mac to get started.
Good afternoon. The Metropolitan Short-Term Rental Board of Appeals is now in session for the regularly scheduled meeting of February 28th, 2024. I am Short-Term Rental Chief Bonnie L. McBroom III, and I will be presenting the cases to the board for review in today's public hearing. At this time, I would ask everyone to either turn off their cell phones or put them on silent so as not to disrupt today's meeting. The procedure will be for staff to introduce the case record. At the conclusion of the presentation, the appellant will present their case to the board along with any person in support. If there is opposition to the case, the board will then hear from those parties. After opposition has presented their testimony, the appellant will have a period for rebuttal. The board and their rules provide for cases without opposition 5 minutes total for the appellant, including members of the public speaking in support of the appeal, to present their case and supporting comments. For cases that have opposition, the rules provide that the appellant, including members of the public speaking in support of the appeal, have 10 minutes total for their presentation and rebuttal. The opposition's presentation and rebuttal of the opposition's presentation. The members of the public speaking in opposition will have 10 minutes. This is 10 minutes total, not 10 minutes per speaker. The members of the public that want to submit comments to be entered into the record prior to the meeting that are either in support of or opposition to the appeal, the comments must be submitted to the board staff no later than 5 days prior to the public hearing. And the documentation supporters or opponents wish to provide to the board after the deadline can be presented to the board by providing 8 copies at the public hearing. However, the board may elect to defer cases in order to review any materials received after the deadline. The Metro Code requires that these proceedings are taped. Therefore, it is imperative that anyone addressing the board come forward, speak into the microphone, identify yourself, and then make your presentation. It should be noted that if it is found that anyone has presented false or misleading testimony to the board that would have affected the board's decision, any approval may be revoked at a later date by means of show cause hearing. The board will go through the cases set for the public hearing today. After both sides of the case presentations are made, the board will discuss and vote on the case. The board is vested with the powers to act on cases before us today under the provisions as outlined in section 6.28.035 of the Metropolitan Code. The code requires 4 members of the 7-member board to be present to constitute a quorum. The rules require a majority vote in the affirmative of the members present to grant the appellant's application. In the event that a majority vote is not achieved, the case will remain on the board's agenda for the next regularly scheduled public hearing. Applications that fail to receive a majority of affirmative vote at the next regularly scheduled public hearing shall be deemed denied by operation of law. Any aggrieved party may request within 60 days of the entry of an order an appeal a finding of the board under the common law writ of certiorari in accordance with TCA 27-9-101 and following to the Chancery Court within the same 60-day period. After that time has elapsed, the board's decision becomes final and no further action can be taken. If you are an appellant and your case is granted, it will be necessary for you to obtain the permit for which you have applied. It should be noted that the permit must be obtained within 2 years of the board's approval to remain valid. I submit that all cases have been filed in proper order. All appellants have been notified by certified mail as required by the code. All affected property owners have been notified, and the legal notification sign requirements have been met as required by the code. Chairman Caputo, before we move on to cases to be heard, we will take this opportunity to recognize any elected officials, and seeing none, we will continue on with the first case. Our appellant is present. Our appellant is present, so we're now ready to present the case.
So, Mr. Arsenault, you heard the instructions from Mr. McBroom. So he's going to start and share with us the Metro case, and then we'll hear from you next, okay?
This property is 2006A Ireland Street, case number 2024-003. Mr. Toby L. Arsenault, the appellant. This is an RM20 zone. This is governed by BL 2023-136, and the board has discretion to lessen the one-year prohibition to apply for a short-term rental permit based on the following criteria as described in the ordinance. Intent, whether the appellant did knowingly commit a wrongful act under this code. Injury to the neighboring residents and properties, whether the granting of relief will be injurious to other properties or residents in the area. Undue hardship, whether the failure to grant relief would result in exceptional practical difficulties or undue hardship upon the appellant. However, any such hardship or difficulty shall not be self-imposed, created by the actions of any person having an interest in the property. Remedial action, whether the appellant has corrected or abated the wrongful activity or condition upon being notified by the zoning administrator of the applicable law. Furtherance of public policy, whether the granting of the relief will substantially impair the intent of the purpose of the code. Whether or not the zoning administrator erred in revoking the owner-occupied permit based on the evidence that the short-term rental property is not the principal residence of the permit holder, the appellant.
All right, Mac, I'm just going to interject here really quick. And so I think there might have been a little mistake in terms of the instructions about the applicability of the new ordinance, because I was just looking back on it to review it. And the ordinance BL 23-136 basically says the criteria in the new subsection 8 shall apply to any appeal filed after the enaction of this ordinance, which I believe it's enacted on February 8th. And so I think this appeal was filed before that time, which would mean that the new factors would not apply to it, but they would apply to appeals filed after that point. So I think Joy just might have missed that language. And I'm just going to respectfully disagree with the instructions you just received and just give you that information.
If the board decides that this is not under the auspices of Bill 2023-136, it would then in turn be governed by BL 2020-187, in which the board has no discretion to lessen the one-year prohibition to apply for the short-term rental permit. In this case, the decision of the board is whether or not the zoning administrator erred in revoking the owner-occupied permit based on the evidence that the short-term rental property is not the principal resident of the permit holder, the appellants.
Great. Does anyone have any questions for Metro before we hear from the appellant?
Yeah.
Oh, sorry.
You'll need to determine.
We covered so much already.
You'll need to determine whether or not BL 2023-136 is applicable in this case, or if it's 2020-187.
I think Ann is spot on. The language is very clear that the language states this is applicable for appeals filed after the enaction of this ordinance. And I realize that Joey may have given you other instructions and he's not here to discuss it with us, but our learned legal counsel it's black and white in the ordinance that it is effective as of the date of enactment. This appeal was filed in December of 2023. I don't really see where there's any room for discussion. But let's discuss it, if anyone has another opinion.
Do we need to take it up on motion?
I don't know.
I mean, if you'd like to have a motion and just to clarify which standard you're using, that's perfectly fine.
Someone could give me the citing. I'm sorry, I have it right here. I'd make a motion that we apply BL 2020-187 as the governing law for this case.
Seconded. Can I see a show of hands?
Seeing that the board has voted in the affirmative that 2021-87 governs, the board has no discretion to lessen the one-year prohibition to apply for the short-term rental permit. In this case, the decision of the board is whether or not the zoning administrator erred in revoking the owner-occupied permit based on the evidence that the short-term rental property is not the principal residence of the permit holder, the appellant. Now, January the 13th, 2023, the appellant, Toby Arsenault, acquired 1206A Ireland Street. May the 3rd, 2023, an owner-occupied permit application for 1206A Ireland Street was submitted. The permit application was processed on May 4th, 2023 by Inspector Robert Osborne. The permit was denied for the following. Inspector Osborne wrote, I started to review the short-term rental application for 1206A Ireland Street and noticed that your insurance had a Louisiana address. After reviewing your deeds of trust and assignment of rent contract recorded with the Register of Deeds, I noticed that on both documents it is listed that you waived all right of homestead exemptions for this property. While also reviewing your address listed on these deeds, which is 36156 Serenity Lake and Lane, Prairieville, Louisiana, I found that you have that listed as your homestead. For these reasons, your owner-occupied short-term rental permit application is denied. If you think we erred in denying your permit application, you may appeal the short-term rental board. If you desire to appeal, please email David Frabit at davidfrabit@nashville.gov. On March the 5th, Mr. Arsenault sent the email to David Frabit, which read, Hi, David, I am planning to open an office in Tennessee and will have Ireland Street address as my primary residence. I purchased the property as an investment because that was the easiest route for the lender and didn't realize that it would make a difference. What steps do I need to take to get the permit approved and or appeal? I do plan to maintain my Louisiana property, but will not claim it as my homestead, but will make the Ireland Street as my primary. Toby Arsenault. Inspector Frabit replied, Toby, once you have completed the transition of relocating to Tennessee and have properly updated your real estate documentation, you may submit a new short-term rental permit application. Any STRP application document that with a date on it expires after 90 days. Any document without a date may be reused if it is current. For resident identification, please provide Tennessee driver's license and voter registration. On August 28th of 2023, an owner-occupied permit application was submitted for 1206A Ireland Street, and it was processed. On August the 30th, the permit was issued. On June 21st of 2023, an Airbnb website advertisement was posted. July the 6th of 2023, a VRBO website advertisement was posted. On October 23rd of 2023, Inspector John Phelps was forwarded an email complaint from the short-term rental property questions email box for condominiums in the 1200 block of Ireland Street. The complaint was for short-term rental property guests on the roof deck at the condos next door. Subsequently, he was forwarded previous email complaints that had been sent to the Board of Zoning Appeals email box. The numerous emails are included at the end of your case file. The following is an aerial photo of the location taken on February the 19th of 2023. Inspector Phelps began an investigation and made a site visit to identify the various properties. The properties at 1207 A, B, C, and D, and 1209 A and B Ireland Street were issued multifamily, not owner-occupied permits in 2021. This is an RM20 zone district. Not owner-occupied permits were available in RM zones until January the 1st of 2022, after which only owner-occupied permits are available in RM zones. At 1206 A, B, and C Ireland Street, the new owner-occupied permits were issued in July and August of 2023. A neighbor told Inspector Phelps that none of these properties are owner-occupied. Inspector Phelps investigated and gathered sufficient evidence to revoke the 3 permits. It is the position of the Department of Codes and Building Safety that the appellant's principal residence residence is 36156 Serenity Lake Lane, Prairieville, Louisiana. The evidence for the property under appeal is as follows. The employer is GMFS Mortgage, located at 4561 Durham Place, Suite C, Baton Rouge, Louisiana. GMFS Mortgage branch locations are in Alabama 3, Georgia 1, Louisiana 7, Mississippi 3, but no Tennessee locations are listed. Ascension Parish Property Assessor, 23 assessment listing for 36156 Serenity Lake Lane, Prairieville, Louisiana. The owner is Toby Arsenault. Over the Top Properties LLC, 4561 Durham Place, Suite C, manager Toby Arsenault, 36167 Pleasant Hills Court, Prairieville, Louisiana. 36167 Pleasant Hills Court, owned by Toby and Lorinda Arsenault from 2004 through 2013. Serenity Lake Lane HOA LLC, Toby Arsenault is a board member, and 3156 Serenity Lake Lane, Prairieville, Louisiana. ABI Group LLC, Toby Arsenault manager, address 36156 Serenity Lake Lane, Prairieville, Louisiana. 8 vehicles are registered in the name of Toby L. Arsenault at the address of 36156 Serenity Lake Lane in Prairieville, Louisiana. On Facebook, Toby L. Arsenault works for GMFS, lives in Prairieville, Louisiana, from St. Francisville, Louisiana. LinkedIn, Senior Vice President, GMFS Mortgage, August 2008 to the present, 15 years, 3 months, in October when this was investigated. 1206A Ireland Street, deed of trust, assignment of rents indicating the property is to be rented. Assignment of rents is generally not in deeds of trust for properties that are going to be owner occupied. Owner address at 36156 Serenity Lake Lane, Prairieville, Louisiana is listed on the deed of trust. Spouse Lorinda Arsenault, LinkedIn, Prairieville, Louisiana, Balfour Sales, and her voter registration is in Ascension Parish, Louisiana. November the 17th, 2023, the permit revocation letter was sent. On December the 2nd, 2023, the permit was revoked. December 21st, 2023, short-term rental appeal was filed. Airbnb and VRBO website advertisements from the investigation. The property listed for sale on Zillow on February the 2nd of 2024. It has been listed for 11 days on that date, February 2nd, 2024. Airbnb website advertisement on 2/5/2024 was set for 31 nights minimum. And photos from the 4 site visits between 1/31 and 2024 and 2/5/2024, where the garage for the unit was empty, and there was also a supplemental package of photographs submitted at a later date.
Okay. I'm still scrolling through some of this.
Can I ask a question?
Yeah, please.
I want to clarify the timeline, Mac, about it's at the end of the first page, where it has the dates just sequentially, May 5th, August 28th, August 30th. Then June 21st, the advertisement on Airbnb was posted, and then July 6th on VRBO. Are those dates correct?
Now, I'm sorry, would you run that past me again?
It's at the bottom of the very first page. It goes from May 5th to August 28th, August 30th, then back to June 21st, and then July 6th.
Yes, your question revolves around the posting of the Airbnb?
Yes.
Yeah.
That is the correct date.
Okay, so they were advertised before the permit application on August 28th. Is that?
Yes, sir. I believe it was probably associated with the initial permit application, but
Okay.
that is the date.
Okay, thank you.
Anybody else have questions for Metro? No? Okay. Thank you, Ms. McBroom. Okay, Mr. Arsenault. We are going to set a timer, and it's a 5-minute time allotment. So by all means, take as much time as you need. You don't have to use up the whole 5, but tell us about your situation.
Okay, and I have some additional documentation that's sent out.
Sure, give it to Matt. He'll bring it around.
And if you could be sure to turn the microphone on.
Yep.
Thank you.
And as you start, sir, give us your name and your address for the record.
Okay, Toby Arsenault, 1206A Ireland Street. I guess we can start with Mr. Loico, am I saying it right? With your question, it was listed on Airbnb during those times, but it was a 30-day rental until the permit actually came in, but that is correct. It was listed there, but only for the 30-day rental. What I'm providing you guys. So I guess I can start maybe with my quick 5 minutes of purchasing this property while we moved here. Really three reasons. One, we have lifelong friends that have moved here to Nashville. Second, we have a really dear friend that's opening a church here, which I think I submitted to you guys some additional documentation that you should have received beforehand. The launch was actually this Sunday. We're very much involved in the launch of that church. The third is with those moves and the want to move here, we are opening an office. I am in mortgage lending, as you guys heard, GMFS, employed with them, been for a while. Our intent is to open an office. We would have opened that office probably 7 or 8 months ago, but as you guys all probably know, the rates are at a level that is not conducive to doing that. So that has been delayed, but we do still plan to open an office here, and that is my intent of moving here, along with those other 2 personal reasons to move here. So that office is still going to open. I gave you guys a second is, I think in some of the findings mentioned that the Tennessee office is not listed as an office on our website. That's correct, because it's not open yet, but one of those documents show at the top, GMFS, that we have a Tennessee license as a company. So just again, as showing that we do have a license to do business in Tennessee, and our intent is to eventually open that office here, which is why I'm here. As far as going back to when we first closed on the property and the property deed of trust being as an investment, being in lending, the lending industry has not adopted the short-term rental only owner-occupied combo at all. If an applicant applies with us and they intend to rent the property at all, then we're going to deem that as an investment property and close that way. Again, I'm not saying we're the only lender that makes all the rules, but I haven't found a lender yet that if you apply as an applicant to purchase a home and you're going to rent that property at any moment in time, then it no longer can be considered an owner-occupied property. From a lending standpoint, it is going to be considered an investment property. So that's why that deed of trust shows that, because I do, from the beginning, plan to rent the property when I am not there. From the beginning, as you guys see my original application, I intended to retain my Louisiana property, still the case today. I have 4 children. One is still in high school. She graduates in May. When that happens, my wife will then transition here to Tennessee as well. But we will still maintain that property because of our family ties and 4 adult children that are in Louisiana as well. So that's the reason why we haven't. As far as the vehicles registered, with 4 children, 7 vehicles, we have vehicles all over the place. Registering those vehicles, I tried. I have insurance with Farm Bureau. I was advised that until my wife makes her transition to the permanent residence here, primary residence, that the vehicle would not be able to be insured until we're both, since we're married, until we're both have Tennessee as our primary residence. She has to keep her residency there until my daughter graduates high school, which is in May. Ms. Jordan, who initially submitted this complaint, you guys are probably very familiar with her. She was supposed to be here today. I met with her last week, or didn't meet with her, saw her on the street. She saw the sign, hey, I'm going to be there next Thursday in support. So I'm very disappointed that she's not here. So she is the neighbor who wrote the complaints. in my opinion, reading those complaints, I think you guys will see the same 95% of those have nothing to do with short-term rental and residence. It's those complaints are lots of other things, I think, if you guys would go back and read. However, before my time elapsed, I think the most compelling piece is it's a Gmail. It's from Goodnight Stay, which is a management company. If you noticed from the beginning, from July, which is when it was initially listed, July and August, there were no reservations at all. It was because it was a 30-day. I can't do the 30-day because I'm in the property. So I can't afford to do a 30-day rental and not be there. And then I have to rent the property in order for me to be able to budget the property, which is also why it went for sale. I can't continue to not supplement the income from the property. It's time. So if you look,
We are at time.
okay, all right.
All right. I'm sure you'll be able to cover some of this in some of the questions from
Okay,
me
great.
and my colleagues. So I think that was going to be one of my first questions, and I think you alluded to it there at the end. Do we understand correctly that this property is actually up on the market right now to be sold?
It is, yes. Yeah. And only because of the outcome of this. I can't afford to keep the property and not have the ability to help supplement. And then the 30-day is not going to help me because I need the property to somewhere to stay when I'm here. And so I wouldn't be able to do a 30-day rental out to someone else.
Okay. Go ahead.
So when did you move to Ireland Street? I'm a little confused about the February 2023 pay stub because it seemed like you hadn't moved to Ireland Street at that point.
Yeah, so we had some issues with occupancy certificate early on in the beginning. So I made the transitions, did all those things, but we did not get our occupancy certificate a few months after closing. It was a major ordeal with Metro, not because of this, but some builder had some things to do that we could have occupied the property, but I chose not to until we got that certificate. So that was some delay and some time crossing there.
And so when did you move to the Ireland Street address, and how often do you stay there?
Yeah, so, and again, May, March, April, I'm 10 to 15 days out of the month there. In Louisiana, other offices, as you guys saw listed, my job is managing all of those offices, so I'm traveling there often as well. I would say 10 to 15 days I'm occupying the property here.
And then I had one more question, if that's okay.
Yourself out.
So the business registration for over-the-top properties where you filed your annual report on September 19th of last year with you still being at the Louisiana address, can you explain that?
Yeah, so that registration for those LLCs aren't necessarily my primary residence. It's the domicile of that LLC or the office. So there's another LLC that has a different address. So that registration isn't a primary residence address. It's just an address of where that LLC is. I just didn't see the need to change that. All my records for years have been there. I'm maintaining that property, so it's just easier. And that registration is not asking for primary residence.
Okay, thank you very much.
You know,
Nothing from Terrence, Mike, Whitney?
Shirley,
I wanted to
going ahead.
confirm the date that you moved. I'm sorry, I didn't catch a solid date.
Yeah,
I got
so-
there's
so
3 months of arranged.
Yeah,
Do you have a date?
I was even in February, I was in and out, you know, from there. So I would say even in February, I was there 10 or 12 days. But again, was even hesitant at that point until we got the permit. So March, April was probably where I was consistently spending some time there.
Okay. And have you changed your driver's license to Tennessee?
I have, you guys should have record of that and voters registration as well.
Oh, thank you. Okay.
Yep, there's an email requiring packet and a voter registration card.
And
Any-
just,
Go ahead,
sorry.
please.
So to clarify, March, April, but before you obtained the owner-occupied permit, you moved to Ireland Street,
Yes,
Okay.
yes.
before
Yes.
August, essentially.
Before the permit was, yes, that's
Okay.
correct. Yes.
Thank you.
Surely someone has a question about the number of reservations that I
No,
get
we
to
don't.
cover?
We'll let you know when we have questions for you.
All right.
So you were, in your estimation, the way that you're answering Nicole's questions, you feel like you really moved in March and April. But in May, your application was denied and your answer was, I plan to move. I plan to move. So you really hadn't moved.
Yeah, I mean,
Because in May, when you were denied a permit that you wanted,
Sure.
that would have been important to you financially for this investment property, you would have been like, oh, heck yeah, I moved here. I'm living here. Come on by. We'll have a cup of coffee, right?
yeah, I mean, again, a permanent move, to me, it's my primary residence, 10 or 12, 15 days there. But yes, I guess you're correct there.
Great. Anybody else have any questions? Okay, very good. Mr. Arsenault, thank you so much for your time. We're going to debate amongst ourselves. I'm sure that there'll be stuff you want to interject on, but please don't, because the public hearing will be closed. So you can pop back to the gallery there, and we are going to discuss amongst ourselves.
Quick for me, I think we have three pretty dispositive pieces of evidence in front of us. The voter registration card, it's on, sorry, just not close enough to my face. Three pretty dispositive, in my opinion, pieces of evidence we have are the voter registration, the driver's license, both of which were issued on May 17th. So that would have been before the new permit application that was considered and issued. And to me, and along with the tax document, is sufficient to establish, in my opinion, residency at the address indicated.
I would agree with that, Board Member Bond. I think I was satisfied with the explanation of essentially all of the, what would appear to be conflicting information. The fact that his wife still lives in Louisiana, they have a daughter in high school, they have several children, adult children in Louisiana. Essentially, I agree with you about the documentation. I was also satisfied with the explanations from the appellant.
That surprises me because those things were obtained under the instruction of this is how you're going to get the permit you want. So yes, he got them, 100%.
Right.
But I don't think they change any of the facts that have been brought before us, which is, we heard, this came up because there was a neighbor who said, this house is not inhabited. This is not someone's permanent residence. You've got children in Louisiana. You have a wife in Louisiana. I completely understand and can see that Mr. Arsenault has every intention, or at least appears to have every intention, of eventually moving here. But I don't think that he has. And just because he followed the steps that were laid out to him in an email saying you need to have these items to show that you live here, doesn't mean that he lives here. And I think when he does live here, super, he can have an owner-occupied permit. But I don't think that we have this gentleman living here.
I see exactly where you're coming from. I think the issue for me is we don't have a stable test for living here. And I think that we have to go with the best proof that we have before us. And the account of a neighbor could carry some weight, but the neighbor isn't here. And there isn't any evidence that the neighbor submitted, in lieu of her attendance. So barring that, I have a voter registration card, which you have to certify to the state that you are a resident of that county in order to obtain under penalty of perjury. We have a driver's license that you also cannot obtain unless you become a resident of the state. And we have tax documents on which you have also made a legally significant certification that this is your address. We've had cases in the past where that's come into question, and we've sort of questioned the veracity of those things. I just think that the story lines up here based on the appellant's testimony, and I believe those documents.
I will say, Ms. Jordan is not here, but we met her last month because she was here on another appellant.
Gotcha.
And I wish she had come because she did have a lot to share
Right.
about the neighborhood and the fact that, in her estimation, she's kind of one of the only people that still lives there.
Right.
That it's all,
Well-
Airbnbs around her.
So I do want to point out, I don't think it's appropriate for us to take into account what she said about another case. And I did want to point out her email actually questioned whether someone was living at 1206B, not 1206A. So it says, I have not seen this resident that is renting out this house at 1206B. We're talking about 1206A here, and she's not here and hasn't provided any evidence about 1206A. I also think that's all I'll say on that issue.
I see both sides of the fence on this one. You know, by his own admission, I'll tell you the first thing that I look at, and that is, he says, I moved at X time. Today, that's what he said. I moved these months. But if we look back at the email, it said, no, I actually moved these months. I think that's a very telling thing for me as to what's convenient at the time for the story. So I'm having trouble getting over that hurdle. By his own admission, he travels a lot. And he oversees offices in numerous states. So between traveling to different offices in numerous states and having a wife and at least one child at home still, I don't know that he definitively has somewhere that he is for an extended amount of time each month for that to be where he truly lives. I think given the fact that he is somewhat nomadic, there is some fluidity as to where does he lay his head most nights of the week. I will say that the listing photos for this property do not look like a primary residence. They seem to have been decorated specifically to target the short-term rental market. There's a mural of Legends Corner and Alan Jackson by the bedside. So that's not typically what you would see in the decor of an owner-occupied home. I do think that he has checked the boxes with some documentation. I'm struggling with whether I'm convinced with it or not.
I did, to the issue of like getting over the hurdle of when he moved, I will say regardless of when it was before August. Based on the testimony he gave here today, I understand it seems inconsistent, but regardless of when it was before August. I don't know that I feel comfortable judging someone's decor choices personally as like an indication of whether they live somewhere or not. But that's me.
Where did we come down on the advertisements? Was that confirmed that those were just 30-plus day advertisements?
I don't think that it was necessarily confirmed. I saw it as an opposite in this case, since we're only deciding
Right.
whether or not it was owner occupied. But yeah, otherwise I would have been interested to know more there.
Well, I think to me, the reason why I think that is important is because how do you rent a property for in excess of 30
Right.
days if it's
you're not-
owner occupied?
right, absolutely.
Not whether or not you're following the letter of other considerations we would have in
Right.
other cases, but
Right,
Well, that was the appellant's
right.
claim during this Q&A, was that when it was listed before the,
Before the August
before,
application.
yes, that it was listed for 30 days.
so then
And yet moved here, you guys are ready to believe in March or April.
Right.
So can we just go through this timeline one more time so I have it straight in my head?
Yep.
Yes.
Potentially moved here March or April. Then we have the email in May that says I haven't moved yet. Then where do we have the 30-day listing?
In June and July.
In July. And then we have the August application,
Right.
correct?
Right.
Yep.
Okay.
And
But
then, mind you, as you can see in the materials, Inspector Peltz did make visits. There
Right.
was there. Now, I can hear it now, like, oh, well, they just happened to be there on the day that he happened to not be there. But,
Right.
this is why we send investigators to
Right.
look into these things. Just, it seems like the investigators never happen upon the person mowing their lawn and, having a beer with a neighbor. It's conveniently never turns out to be the
I'll
case.
acknowledge that this is not exactly the cleanest route to a result that I've ever, supported or reasoned my way through, since I began serving on this board. However, I think if we're going to pin it to something, if we're thinking about the decision in terms of what happens after hearing the appealability and the winnability of an appeal on an issue, if we make a decision based on sort of the more granular elements, such as what the decor of the home looks like, what the aerial shots look like, versus other sort of more solid indicia, such as your voter registration card, which was clearly issued before and was issued upon certain legally significant certifications. We have 3 documents that have legal import, that are in the record, that are not disputed as to the validity of those documents. And we've never, I don't think in any of these cases where this is the issue, counted number of days. We have rested the decision primarily on what ties you to this location. And it's establishing a primary residence, not necessarily how many days you live there. I think there have been cases where we have looked at that to say, hey, you weren't here really at all. If you're here 2 days a month and you're somewhere else the majority of the time, and it's a very clear split, then that's probably not your primary residence, but there was other evidence to support that.
What ties you to a place like your wife and your child might tie you to a place.
No,
I think we
absolutely.
have come down on a few occasions to I don't know if it's a state presumption that your domicile is the place where you're presumed to live where your spouse lives. That is the presumption in state law. Am I right about that, Ann? Is it state law or is it county?
I believe that's state law.
State law. You are presumed to live where your spouse lives, which I think that's a pretty strong tie.
It is. No, I would agree with you there, but I also know you can only be registered to vote in one place.
True. But I think when I look at the May email saying voter registration card, you come up with a voter registration card, it cheapens it substantially.
I just don't think that that's fair. Laying out the requirements for obtaining a permit, like you could look on the website and see I have to have my voter registration card and my license. So it's like a change to that as my primary address. I really feel uncomfortable when we talk about, well, you only did it because XYZ, because we don't know. We just don't know that.
Right.
And I also feel uncomfortable making decisions about people's personal lives, how they choose to conduct their marriage and support their children is really none of my business. But I do see that we have the neighbor who has,
The public hearing is closed.
I think we are able to reopen it by a vote. I know that people on the board were wanting to hear from the neighbor. So, I'm happy to be outvoted, but
I'd like to hear from the neighbor.
Ms. Jordan? Stand by if you're willing to talk today, which I guess is why you came. We're going to have a vote as to whether or not we're going to reopen the public hearing so that we can hear from Ms. Jordan. And if we reopen the public hearing, we don't need to do anything other than hear from Ms. Jordan and Q&A with Ms. Jordan, right?
That's correct. You can do
Okay.
that.
So moved.
I'll
second.
Show hands.
I
Okay.
have a question before we proceed, though.
Okay.
If Ms. Jordan were here at the beginning, the appellant would be allowed 10 minutes.
Oh, God.
So I think, and he's used 5, so I think he would be offered the opportunity to respond. Is that not right?
It depends on whether she's speaking in opposition or if she's in support. I believe she's here today in support, so the 5 minutes has been expired.
Ms. Jordan, are you here to speak in support of Mr. Arsenault or in opposition to Mr. Arsenault? Toby. Okay, well, we don't need to open the public hearing because only 5 minutes is permitted, right, total, for Mr. Arsenault and anyone who's speaking in support. Since Ms. Jordan is here speaking in support, that time has elapsed.
Yeah.
So,
But we
do
are
we need,
able to take a vote to extend that, right? I mean,
My thought process is if she is here in support, that helps me without the testimony.
okay.
great.
Personally, but if anyone else still wants to,
I don't need to hear anything more.
ultimately, I told you when I started talking, it was, I can see both sides of the fence on this. I do think that there are certain legal ramifications for and certifications that are made in obtaining those documents.
Right.
And I think that for my thought process related to the decor aside, I do think that that is worthy consideration, coupled with, in particular, the neighbors' support in person today.
Right.
I'm kind of similar, and well, I don't want to speak for everyone here. My gut says that this is not a primary residence, but the evidence says that it is, and I have to follow what the evidence shows, as Terrence laid out. So,
Great. Do we have a motion?
Yes, I move that the board find that the zoning administrator did err and grant the relief that is appropriate. Wait a minute. No, that's a bad motion. I'm sorry.
You want to go again?
Yes, I vote that the board find
You
that.
move.
I move, excuse me, I can't talk today. That the board find that the zoning administrator did err in denying the license and that the license should in fact be reinstated, the permit.
Do I see a second?
Second.
And a show of hands. There you go. It carries. Alicia, if you're keeping track, that was 4-1. Great. Very good. Mr. Arsenault, you have prevailed today. And unless we have any other business, we will consider today's hearing closed. Very good. Thanks, everyone.
Thank you.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.